We have a 2-for-1 today. Sarah Boone and Lori Vallow. I don't normally mix them, but I have limited time. If you want to see a full breakdown of what was submitted today in Sarah Boone's family law case, Tanika's 2 cents already has a video up, and I'll link you to it in the pinned comments. But what I want to talk about is a singular point: that both parties have 30 days to submit a parenting plan. Yes, you heard that right. Convicted murderer Sarah Boone is going to be writing to the court explaining what control she should continue to have over her son from prison. I believe she's done her own version of this in the past, and it was pretty extreme. She wanted him like every week in holidays, and she basically would be running this poor child's life. I'm hoping the judge goes with whatever Brian Boone wants. In fact, I am hoping the judge goes with Brian Boone and then cuts whatever he gave Sarah out of it. I just want them to be free of her. Now, with that being said, we need to talk about Lori Vallow. Now, there were oral arguments heard this morning that media cameras didn't make it to, but there is a court feed uploaded, but being a court feed, it's very bad quality, so I'm going to talk you through it. But before that, we need to talk about the state's reply to Lori Vallow's motion, because this is all going to get discussed today. Let's begin. The state of Arizona, through undersigned counsel, responds to defendant's motion to disqualify Judge Bresky. Defendant's motion should be denied since established any judicial bias, appearance of bias, or fundamental error. I've noticed sometimes with the state's responses, I feel like there's a word missing. Defendant's motion should be denied since established any. Didn't establish any? Defendant's motion to disqualify the judge relies heavily upon the fact that Judge Bresky has provided legal reasons to deny many of the defendant's motions. He sustained objections during the trial, and he found no prejudice to the defendant when he excluded 18 days and scheduled this trial to begin on June 30th. So there was some talk about the delay between the trials. Lori was complaining about that, and they mention it here. It was excluded because it was a scheduling thing. The defendant previously incorporated her allegations of judicial bias in her motion for a new trial. She also made an oral motion to disqualify this judge on May 14th, 2025. The judge issued a minute entry providing his reasoning for denying a new trial based upon defendant's allegation of impartiality by the judge. You can check that out in the playlist. We did cover that. On May 14th, 2025, the judge put on the record his reasons for denying defendant's motion for the judge to excuse himself. The court put on the record that he had no personal bias towards the defendant, he has accommodated her requests, and he has allowed her additional time beyond that is allowed in the rules to obtain expert testimony, and that denying her motions when they had no legal basis is not evidence of bias. A trial judge is presumed to be free of bias and prejudice, and a defendant must show by a preponderance of the evidence that the judge was in fact biased. And here we have some case law. In Turney, the Supreme Court found he violated the 14th Amendment, deprived a defendant of criminal case of due process of law to subject his liberty or property to the judgment of a court, the judge of which has a direct, personal, substantial, precusatory interest in reaching a conclusion against him. Applying the standard, the court has found judicial recusal constitutionally required only in rare circumstances. For example, when the judge had a financial interest in the outcome of a case, or in the criminal contempt context where a judge had no pecuniary interest in the case but was challenged because of a conflict arising from participation in an earlier proceeding, that suggested he had a strong interest in the outcome. In Granados, the defendant alleged bias based on the judge's ruling and admonishments to him regarding his behavior in the courtroom. Granados claimed the trial court gave the appearance of bias by not allowing Granados to interrupt court proceedings, removing him from the courtroom during voir dire, and sustained general objections during Granados' testimony. Granados further cited the fact that the judge sua sponte objected to the admission of testimony and prevented the court interpreter from translating inadmissible hearsay. The Arizona Court of Appeals found these allegations did not establish judicial bias, the appearance of bias, or any fundamental error. Defendant's argument in support of judicial bias are similar to the allegations made by the defendant in Grandiose. Defendant's motion to disqualify the judge should be denied since the defendant has not established any judicial bias, appearance of bias, or fundamental error. So, what's so funny is they're taking this guy who is like, you wouldn't let us say hearsay, interrupting the court, and they're like, I mean, Lori's allegations are similar to him. That's kind of funny. They're comparing Lori to that. So with all that being said, we have the oral motions, okay? And I do want to talk about it because I did watch it. It is worth mentioning that this is heard by a different judge than is handling the case itself. The case will be the same man as the first trial. This judge is a woman. There was a media request that they were going to handle, but no one from the media made it. Yes, basically, from what I could gather, the media didn't know this was happening until too late to actually make it because it ended so quickly. That's why we have like the really poor quality version and all of that. Lori and the state both were going to say nothing about the media request until the judge said they would put they don't object if they come in, and then Lori said she objects because she always objects to the media, and then she had nothing to add to the record about that, though, so Lori being Lori. The new judge says that Lori wants the old judge removed for cause with mention of a belt, facial expressions, personal bias, religious persecution, speedy trial, and I covered all of this in the previous videos for her motion. There's a whole obviously motion she filed. State's response was that the state doesn't. That didn't happen. Basically, like, the state's response basically boiled down to, yeah, that's not a thing. And then Lori's back up. The state says she has filed this oral motion trying to get him to recuse. He refused. Lori brings up the quote about comparing herself to biblical prophets, which she claimed isn't what she was doing. But the thing is, he never said prophets. He said biblical figures, which is exactly what Lori was doing. So she's even kind of lying to the judge, because saying someone is comparing themselves to a figure in the Bible or a prophet in the Bible is two different things. Lori complains he denied her motions and said they had no merit. She claims his denials as proof of bias. State points out all prior defense counsel motions were almost exclusively about denying media, and the judge just applied the law. She's really mad the media's involved. All the defendant's motions have been without legal basis, inappropriately ruled on. All motions ruled against isn't proof of a bias if they had no basis in the rules of law. Basically saying, look, if you want to have everything not ruled against, be correct for once. Give the right answer. They see nothing to have him removed from the defendant. Nothing that she actually said is correct. Lori responds. Lori says that the judge is denying denying without conclusion of law. He is just saying deny, deny, deny. Lori complains she is getting new evidence that she has asked in front of the judge for a year and a half. Lori complains about the belt falling off and said that according to I think it was the sheriffs, if the belt was too burdensome, they could bring in an armed guard, but they already used an armed guard, so it wouldn't be an additional cost, so she shouldn't have to wear the belt, so that shows that he's biased. Lori says that she asked for a new trial because she said it came to her attention through the media that a juror said he found out about her prior convictions before deliberations. This was the same juror brought in twice by the judge to admonish him, once for being on his phone and once for talking to another juror about the case, which, if you remember my coverage of the trial, if you watched it, I wanted that juror thrown out back then. But now he continues to be a problem and being brought up anytime Lori gets a chance to complain. The juror went on to another media thing and then just took it all back after previously, according to Lori, claiming he found out about her convictions prior to deliberation. So Lori's defense of the state was like, well, he went and explained more. And Lori's response is, no, that was him taking it back. Basically how they're both going at that issue. Lori claims the judge refused to bring him in under oath, and now she wants an impartial judge for her next trial. She just wants to have an impartial judge. So this judge that's overseeing this motion to remove the judge in the other case takes info from both sides, says not liking the previous judge's legal rulings isn't enough. Whether he should have ruled differently with the jury member, you can file a motion to reconsider or use it on appeal, but it isn't part of this 10.1 decision. So basically, Lori is trying to have him removed using a specific statute of law, from my understanding, and she is just going off on every other tangent because she's Lori, and they're like, look, throw it in your appeal. And yeah, I guarantee that's going to be a big part of her appeal is going to be that juror. It's going to be a mess. When it comes to the biblical figures quote, that isn't enough either. While she hasn't heard the full context, it sounds like it was involving you questioning about religion, and Lori loses, and no further comments from the state, no further comments from Lori. You can tell she's kind of snappy about it, and that is where we end. So this all happened before jury selection, which, if things happen on schedule, opening statements in the Lori Vallow case will be June 2nd. So we'll see. We'll see how it goes. I'm not planning. I don't know how much is covered of the jury selection, but I'm not planning to cover it. So you probably, unless there's some new motions filed or something, you might not hear me do a video on Lori Vallow until opening day. And then I'll, of course, be watching the trial. And if you didn't watch my previous coverage, what I do is I like to watch. I like to keep notes. I then, whenever they take a break, I record a video with my notes and my thoughts for that section of the video, have that saved, and then I start fresh watching the second half. I do that for any segments we have so that I can have my at-the-moment response as we go to the trial. I combine it all, I render it all, and then that is what I premiere for all of you to watch. So if that is something that interests you, hit the subscribe button, because that is what I plan to do. It's what I did last time. There is a playlist with a ton of Lori Vallow information. There is I think it's like 8-hour video, which is basically a combination video of all of my Lori Vallow court coverage from the first case. So if you just wanted highlights to go through it, it's like 8 hours long. So maybe something to listen to in the background this weekend if you have time, if you're really wanting to catch up and know what was happening, because then a lot of these complaints are going to make more sense to you, because there's a decent chance outside the presence of the jury, Lori is going to re-complain about the first trial again, and you might be a little confused without all the context, but it is all there in my previous recaps. I hope you all have a great weekend, and I'll see you in the next video.